Constitutional Court has ruled that only the Sishen Iron Ore Company, a Kumba Iron Ore subsidiary, may apply for the rights to 21.4% of the Sishen mine in the Northern Cape that once belonged to steelmaker ArcelorMittal. Now, Peter Leon is a partner at Webber Wentzel, an expert in this field. He joins us on the line for more. Peter, what is the significance of this judgment, which seems to have, the whole issue seemed to have arisen, perhaps not to be too flippant about it, but that ArcelorMittal omitted to renew the rights, and this led to a whole unexpected course of events and a long legal process.
Absolutely, David. I mean, the thing is that, as you say, ArcelorMittal did fail to convert its rights by the 30th of April 2009, which is the cut-off period for converting old order rights under the Mineral and Petroleum Resources Development Act. But the decision is very important in terms of sort of laying down what the law is in relation to the Act's transitional provisions, but also very emphatic about the rights of existing right holders. And obviously that's important for security of tenure and the rule of law. And the main loser in this case is obviously Imperial Crown Trading, which you may recall was granted a prospecting right over the Sishen Iron Ore mine by the Department of Mineral Resources in 2009.
Well, there were accusations of crony capitalism, of shadiness of some kind in the awards of this, particularly being that ICT, Imperial Crown Trading, wasn't known and didn't appear to have the expertise. So would this be prompting a rethink in attempts to give rights to empowerment companies, which that was certainly presented as?
Well, I don't know whether that would happen, but I mean, I think it's certainly a lesson for companies like Imperial Crown Trading, which had absolutely no, the company was cobbled together at the last minute, had absolutely no track record of prospecting or mining or exploration or anything else. That opportunistic companies like that are basically going to be shown the door by the courts quite correctly. And although the Constitutional Court didn't really criticize the Department of Mineral Resources in the way some of the lower courts did, I think it is a lesson for them that security of tenure for mining companies such as Sishen will be protected and guarded by the courts, and that's very important in terms of maintaining investor confidence in the South African mining industry, where post-Marikana there have been a lot of concerns both internationally and domestically about where the mining industry is headed.
From what you've seen of the court cases, the long process, as you say, it started in 2009. It's nearly 5 years process. How will the DMR, the department, react to this?
That's a very good question. You'd have to ask them. But I mean, the interesting thing to me is that, in a sense, they made common cause with Imperial Crown Trading in the litigation, which I think is unfortunate, because at the end of the day, the department is the regulator. It does need to behave in an impartial manner, and I think in this particular case it showed some partiality. So hopefully this case, the fact that they have lost it after going through 3 courts, will be a lesson to them as to how they have to behave in the future.
Thanks to Peter Leon, a partner at Webber Wentzel, on that big Constitutional Court judgment endorsing the Sishen mineral rights for the Kumba subsidiary.